talk about what's called the clarity standard. It's one of the six standards of statutory review for the Office of Administrative Law, the OAL, when OAL reviews rulemaking files. The OAL, the Office of Administrative Law, unless there's a specific statutory exemption, is required to review rulemaking files that have been developed by executive branch state agencies when they adopt, amend, or repeal a regulation under California's APA, the Administrative Procedure Act. The APA is found in California's Government Code, and it contains, among other provisions, of course, six statutory standards used by OAL to evaluate regulations. The six statutory standards that OAL uses to evaluate regulations are necessity, authority, clarity, consistency, reference, and non-duplication. A reminder that OAL may not substitute its judgment for that of the rulemaking agency with regard to the substantive content of the regulations. Also, OAL has 30 working days in which to review the rulemaking record to determine whether the agency has demonstrated that it has satisfied the procedural requirements of the APA. So let's take a little closer look at what is called the clarity standard. So what is clarity? It means written or displayed so that the meaning of a regulation will be easily understood by those persons directly affected by them. Failure to meet the statutory standard is the most common basis for OAL to reject a regulation. Now, OAL, again, the Office of Administrative Law, has adopted a number of regulations dealing with their six statutory standards of review. They're contained in Title I of the CCR, the California Code of Regulations. And Section 16 of Title I concerns clarity, and it provides that in examining a regulation for compliance with the clarity requirement of Government Code Section 11349.1, that OAL is required to apply a number of regulatory provisions. First, a regulation is presumed not to comply with the clarity standard if any of the following conditions exist. First, the regulation can, on its face, be reasonably and logically interpreted to have more than one meaning. Next, the language of the regulation conflicts with the agency's description of the effect of that regulation. Also, the regulation uses terms which do not have meanings generally familiar to those directly affected by the regulation, and those terms are defined neither in the regulation nor in the governing statute. Next, the regulation uses language incorrectly, for example, incorrect spelling, grammar, or punctuation. Also, the regulation presents information in a format that is not readily understandable by persons directly affected by the regulation. And finally, the regulation does not use citation styles which clearly identify published material that is cited in the regulation. And a final note, for persons to be presumed to be directly affected by the regulation, they must be legally required to comply with the regulation, legally required to enforce the regulation, derive from the enforcement of the regulation a benefit that is not common to the public generally, or they must incur from the enforcement of the regulation a detriment that is not common to the public generally. So again, that is the clarity standard, one of the six standards of review by the Office of Administrative Law when reviewing regulations adopted by California regulatory agencies in the executive branch.